So hello and welcome to the overview of corporate finance and management issues in company law. My name is John Lowry. I'm a professor at UCL, and together with Alan Dignam, who is a professor of corporate law at Queen Mary, we convene this course. We also co-author the study guide and we co-author the recommended text. The focus of this course, as with foundational issues in company law, lies with the Companies Act 2006. There are other related statutes, but the backbone of the subject is this modern piece of legislation that followed a major reform exercise that the Blair government in 1997 announced as trying to update company law for the 21st century. As you already know, perhaps, there are 1.4 million registered companies in the UK, and 99% of those companies are private companies, meaning that the big public limited companies only account for 1%. You should bear in mind that companies are made up of two key organs. First, the board of directors, and second, the company's members, sometimes called shareholders. Now, the relationship between those organs is critical and lies at the heart, at the functioning, if you like, of the company. So this course will consider three aspects of the key relationships that lie behind a company. The relationship between the company and its senior managers, the board of directors, the relationship between the board of directors and the members, sometimes called shareholders, and the relationship between the board and the shareholders. A key focus of the course is also on corporate finance, i.e. the capital fund that a company has to have in order to conduct its business activities. And so we will consider the regulations in place and the legal principles in place that are designed to protect the company's capital fund from misuse by those who manage the company, its directors. Because one of the key anxieties of the law here is to ensure that company creditors, as far as possible, can look to the company fund for payment of the company's indebtedness. That's the theory. But we'll also be looking at the sort of practical implications and whether the law is sensitive to those practical implications. The course also traverses a whole range of other sort of facets of this subject, namely the duties that directors owe to the company. It also looks at the rights of shareholders and gives certain emphasis to the modern corporate governance debate. In other words, having accepted that companies basically operate to make a profit, at least limited liability companies, the debate that I suppose goes back now some sort of several decades is whether or not companies should take into account the interests of other constituencies in their operations. For example, not just the interests of shareholders who obviously want profit maximization in order to enjoy a return on their investment, but whether companies should take into account the interests of the communities in which the business operates, the interests of the environment, for example, the interests of the customers of that company, the interests of creditors of the company, and so on. So there is an interesting and exciting debate that has been going on as to whether the focus of company law should be changing. The course is an amalgam of topics. It traverses the corporate governance debate. It looks at some very topical and challenging questions as to whose interests companies should be operating. It considers directors' duties and whether those duties should be owed solely to the company. But it also embraces theoretical questions about corporate management. It embraces historical underpinnings that is really key to your understanding of company law. So it's a rigorous course, is a very interesting course, and I very much hope you enjoy your studies.